What are the type of questions that an administrative law judge will ask you at your Social Security hearing, and how you can avoid making mistakes or being tricked? Your big day is finally here. You're going to be telling the administrative law judge all about why you're disabled and you can't work. Now, in the first part of this two-part series, I covered questions about past work and your medical history. Now, what was important about that was we're going to address the 5-step sequential evaluation. And at step 4 and 5, the issue is, can you go back to the lightest job you held in the 15 years before you became disabled? And is there other work that you can do in the mythical national economy? Now, you understand what really happens at a Social Security hearing, because many people think that they're going to be able to tell the story of why they're disabled, why they can't work, why they've worked all their life, and why they could work if they could, and why they're more disabled than their deadbeat neighbor or their deadbeat relative who shouldn't be getting benefits at all. Unfortunately, as I've explained, it doesn't work that way because the judge has to use that 5-step sequential evaluation test. And what's really crucial is steps 4 and 5, as I've explained. Now, the judge wants to hear your story in terms of your symptoms and your functionality. But unfortunately, I know that you have no clue about how to tell that story, and you can make mistakes if you try to represent yourself or rely on a judge to find that you're disabled without giving the judge a path to get to that decision. Now, you can be assured that the judge has reviewed your file, your medical records. They've made a preliminary decision in their mind about whether they want to pay or deny your claim. But they've got questions, and they want to hear your story. So let's get at it. Well, first off, do you have a treating doctor? And if you don't, too bad, so sad, because you're going to lose. Now, the next issue is, how long have you been seeing that doctor? How often do you see that doctor? If you say that you can't work and you're only seeing the doctor once a year, that's not going to fly. What treatment are you getting, and what is the result of that treatment? Are you getting better? Are you getting worse? Are you remaining the same? Are you having any side effects from the medication that you're taking? And if so, how does it impact you? And has the doctor changed your medication because of the side effects? Has surgery been recommended? And why haven't you gotten that treatment? Now, you're not required to undergo surgery, but you need to explain why you aren't having surgery. What other treatment have you refused? Are you taking the medication as the doctor prescribed? Are you doubling up, or are you even selling that medication? So, what are the mistakes that you can make? Well, obviously, if you don't answer honestly about the frequency and the nature of your treatment, that's a problem. If you don't answer honestly about the impact of the treatment on your symptoms, that's a problem. If you don't tell the truth about the treatment that's been recommended and refused, that's a problem. If you don't tell the truth about taking the medication as prescribed, that's a problem. The judge will have read your medical records. So what are the tricks? They'll try to get you to exaggerate your symptoms, exaggerate your compliance with treatment, put you on the defensive about treatment recommendations and any refusal to follow those instructions or to accept invasive treatment. The next area of inquiry is going to be activities of daily living. The judge is looking for inconsistencies between what you say you can do and what you do. So, how long can you sit, stand, stoop, bend, and lift? How much can you lift? Do you have any trouble bathing or dressing? Do you cook? Do you do the laundry? Do you clean the house? Do you take out the garbage? Do you go out to dinner? Do you go to church? Do you go to social organizations? Do you drive? How often and how far do you drive? The judge is testing you here to see whether or not what you're doing is consistent with what you've told the doctor and what you've testified to so far in the hearing. So what are the mistakes that you can make? Well, the major mistake is failing to testify consistently with what your doctor said, either in the records or in the residual functional capacity forms. That inconsistency is just really going to destroy the case. The other thing is failing to give examples of problems that you're having doing tasks and failing to explain it in terms of symptoms and functionality. Using weasel words like sometimes you know, lying about the use of alcohol or drugs. That is a huge problem. Well, how about tricks? Some judges will try to get you to exaggerate your activity so you agree that you can lift more than 10 pounds frequently, sit more than 6 hours in an 8-hour day. Why? That means you can do sedentary work, and that will probably result in a claims denial. They'll try to get you to exaggerate what you do around the house so that they can equate that with an ability to work. They'll try to get you to minimize your use of drugs or alcohol so that you're not believable. And they will test you about your compliance with the medical treatment. Now, no, they've read your records. This is important because the judge is the credibility and decision maker. You need to make sure that your story is truthful and honest and believable and is not contradicted by medical records. This is a test. You need to be prepared for the questions you're going to get and how to tell your symptoms in terms of symptoms and functionality. Now, some people will say, well, that's not necessarily easy to do. Well, yes, it is, because you need to be truthful about what you're doing, but to answer those questions in a way that explains the impact of the symptoms. So, for example, if you have problems with your hip and you have difficulty standing, you need to be able to explain why it is that you are using a chair at the stove. And I don't want you to be embarrassed or offended by the judge's questions, but one of the things that you never should do is to argue with the judge. They've read the records. They know what the records say, and you don't. So I think it's important that you read those records. Now, remember, we do things differently. If you go to a hearing, we prepare a memorandum of law for the judge. We prepare you for the hearing with videos and live preparation by me. I'm present when you're at the trial. So you never have to worry about what's going to happen at your Social Security hearing. If you don't know what to do, it's time for you to call us at 727-894-3188 to learn more, not only about your rights to Social Security, but how we can help you get the Social Security disability benefits you deserve.